there was the power to reconsider and issue a vacator. Then the next question is there a review over that decision? And if so, such that a stay of that vacator, is there a problem with that decision, or not stay, but a postponement of that vacator is warranted? So the first question again, we revisit the question of whether the decision to vacate the extension is reviewable. And I guess I start with the same sort of point that if you look at the factors that the court considers, you look at whether, how much of this was based on individual analysis, individual records, how much was based on examining things that are within the agency's expertise, such as examining country conditions and assessing reports from the State Department, from various agencies, or is it more procedural? And it does seem here that the reasons for the vacator, vacatur, I don't know how to pronounce that word. I'll call it vacator, it's easier. Whether that is something that is more collateral than sort of central to what the statute, to what section 1252 is about. Or 1254 B5A or B is about. And so again, I'll turn to the government. It does seem to me that these were not decisions based on an assessment of country conditions, based on foreign relations and this sort of thing, but really kind of looking at procedurally whether Secretary Mayorkas essentially screwed up and caused confusion, did something in violation of the TPS statute, it created a sort of procedural problem that needed to be fixed. Putting aside the merits of that, is that the kind of thing that is not necessarily within the agency's expertise and doesn't depend on records of individual TPS beneficiaries or specific facts about the country? It could have been any country. I mean, it didn't have to be about Venezuela. It could have been, if he had done the same thing with Haiti or El Salvador, and the same arguments would be made. So it doesn't seem to be even related to country. It's more about the process. Isn't that the kind of thing that is reviewable?
No, Your Honor.
Okay. All right. Tell me why.
Looking at the vacated decision from Ramos v. Wolf, the Ninth Circuit talks about the merits of these decisions, and those merits aren't reviewable. And here, looking at registration, that's a discretionary function of the statute. The statute gives the Secretary the discretion to determine how registration takes place and when. And so plaintiffs are correct that that these overlapping registrations can take place, but that's within the discretion of the Secretary on how that registration should take place. So here, the Secretary herself has that knowledge and that ability, that the statute gives her that ability to determine whether or not, in her discretion, she thinks that this is the way that the registration should be taking place. And she uses that to decide to vacate the decision extending TPS for Venezuela. And if you're looking for the statutes that I'm discussing, it's 1154A C 1A subromanet 4, which says, to the extent and in a manner in which the Secretary establishes the alien registers for temporary protected status under this section during registration period. And I believe there's another, the period of validity is subsection D2. The Attorney General may stagger the periods of validity of documentation and authorization. So both of those statutes are discretionary in how the Secretary sets up the registration periods.
So it's funny, it depends who's arguing what. To the extent that there's an argument that any secretary, including Secretary Mayorkas, had the ability to determine the manner of registration and to stagger periods, et cetera, there's an argument that that was committed to his discretion in his initial, but then you're saying that if vacator revisiting is within the inherent power of the next secretary, she also has the same power to exercise her discretion and changing the manner of registration, et cetera, et cetera.
That's correct. And I go back to the statement that I made before that the Supreme Court has recognized a couple times that it's hardly improper for an agency to come in and change their policy preferences and ideas and work within the confines of the statute to make those changes. And that's Motor Vehicles Manufacturers Association, where Rehnquist was concurring, and also Department of Commerce v. New York, where the Supreme Court made that same statement. So here, it's true that she doesn't make an analysis of the country conditions, but she does make an analysis under the statute of how the statute should operate. And again, that vacature permitted her to then have space to look at the national interest of the United States and the factors on the ground to determine.
But wouldn't that argue that, I don't see why you couldn't have judicial review, but that judicial review might be deferential if there's some discretion committed to the agency. It doesn't mean there's no review. I mean,
well, the statute does say any determination relating to.
But it's not a determination. If we go back to what determination means, and at least as has been opined in the now vacated Ramos decision, but which drew some support from McNary and other cases, there is some framework for determining what is a quote determination and what's collateral, what's procedural. This still sounds very procedural. I mean, how are you going to do registration, whether you stagger them, et cetera, et cetera. It's not, are conditions really, adverse in a particular country? So it still sounds like the kind of thing that's not within the term determination as used by the TPS statute.
And to that I respond that when looking at McNary, it was a determination and it was of an application, whereas this is any determination, which in Patel, the Supreme Court recognized under a different statute, but any judgment regarding there were a couple provisions that the judgments were regarding. And using that any, they found that any broadened what those judgments were. It wasn't just the final judgment itself, it was the factual underpinnings.
All right, let me hear the response to that. That with respect to whether or not there should be judicial review, that should be informed by the kind of discretion as to the how and the manner and the extent language of C1, Romanet 4, and D2.
Yes, Your Honor, and just to be clear, I'm discussing jurisdiction. Ms. Mounta will discuss the merits. I realize they're bleeding a little bit, but we'll switch over here in a minute.
Okay.
If, with the court's permission, I just want to mention two things briefly before I answer that question. One is that on the question of whether the January 17 extension went into effect or not, I just want to point out in this record already, there's evidence that two of the plaintiffs, Freddy Rivas and Mariela Gonzalez, both already got a extension for employment authorization of 540 days under the January 17 extension. And I'm sure they're not the only ones. And I think what that shows is that effective date is a reference to when the 18-month period starts. It obviously doesn't mean that the extension wasn't in operation yet. And for them, the reliance interest is very real, right? Like they are holding a document, they're still holding it today, which says, I can work in this country for the next 540 days. And now they're saying, the government is saying that document facially on its face, it's actually invalid. So just on that.
All right, so it was operative, whether you call it in effect, it was actually operative. Okay.
Exactly. Now, the second just preliminary point I want to make is we're all talking about these jurisdictional issues as though the Ramos panel majority decision were correct, which sort of makes sense of their concession on the vacatur authority point, because the court held that a claim that the agency has adopted an erroneous interpretation of the statute is reviewable under McNary because the analysis goes to the review of the law itself and not the determination. I understand that's the distinction Your Honor is drawing now. But I just want to put a pin in the fact that if it ever comes to, down the line, our view is that Your Honor's decision and also the dissent from Judge Kristen is a better reading of the jurisdiction stripping statute. I don't think it actually matters for either claim, which I'll get to in a second. I just want to put a pin in that. We're not conceding it. The reason why the second claim is reviewable is actually for a reason that was not discussed at all in Ramos, in any of the opinions in Ramos. And that's because
when you say the second claim,
I mean the challenge, our challenge to the reasons given for the vacatur.
Yep.
It's because the statute says there's no judicial review of any determination with respect to designation, termination, under this subsection. And under this subsection, that's subsection B of the statute, which is what has all the rules for designations, terminations, and extensions. And that doesn't apply to our claim on the merits of the vacatur for two reasons. First, vacatur is not one of these things. It lists the three things: designation, termination, extension. It doesn't say vacatur. Obviously, that dovetails with our merits claim that there is no vacatur. But as far as just construing the jurisdictional statute, does it bar determinations made in vacatures? No, because it doesn't say vacatur in it. And the second reason why, Your Honor, is because the defects that the Secretary pointed to have to do with the registration process. And as Your Honor was just noting, I think the government said today that Secretary Mayorkas could have had the discretion, did have the discretion to set up whatever registration period he wanted. And then there's some back and forth about that. But either way, what you're talking about is the registration process. Process is discussed, section C. And so this stripping provision does not cover determining what to do with the registration process. The registration process is in a different subsection of the statute. And so regardless of these other distinctions that were drawn and what is collateral and what's direct and all that, the subject matter of the stripping provision is focused on country conditions, on the things that are at issues are totally different. They have to do with how you administer the statute. Once you've decided you are going to extend, then you have to set rules for how you let people register it. And our claim on the merits, Your Honor, is that, I'm just going to describe it, I'm not going to defend it, but the claim on the merits is that the reasons that the Secretary gave for why she had to vacate this are arbitrary in violation of the APA. She said that there was something wrong with consolidating the registration period, which I think is the opposite of what Ms. Wong said today. She seems to be saying today there's nothing wrong with it. But either way, our position is it was wrong. It was wrong to say that there's something wrong, that there's something illegal or untoward or odd about consolidating registration process. Ms. Banza will talk about the merits, but whether we're right or wrong about that, that's what our claim has to do with. Our claim has to do with the validity of the reasons that she gave for attacking the extension, and the reasons she gave had to do with this dispute about whether you can consolidate them or not. So that is not within the terms of the stripping statute.
Well, let me ask you, with respect to the stripping statute, and your point about it pertains, 5A only pertains to designation, termination, extension of a designation, and not vacatur. So you're not making the argument that the vacatur here was, in effect, a de facto termination.
It definitely had the effect of taking away the extension. But it is not a termination. I mean, it's not styled as a termination. She said, oh, we're going to make that decision later. And then 3 days later, then they issued the termination.
All right. So there's not a literal violation of the statute, date of any, quote, termination, but it's an argument.
Well, I mean, our merits argument is that any action, however you style it, that shortens the period of an extension after the extension has been made is a violation of the statute. But the way in which they did it. So our argument is it is definitely functioning to shorten an extension, which is a violation of the statute. But the document in which they did it is not an extension. They're saying that there's a separate kind of document not mentioned in the statute called a vacatur that we have implicit authority to do, even though it's not mentioned here. And my point is, obviously we don't think that's true on the merits, but my point is, if you say that there's extra statutory implicit authority in the common law of agency decision-making to do these vacatures, well, then where in the stripping statute does it say that a court can't review what's inside those things? And it doesn't say that.
Well, because if you equate the functional equivalent of termination with vacatur, then I mean, you sort of have to, it's a thin line. For one purpose, you're saying they're kind of the same, they're functionally the same. For another purpose, you're saying, well, the statute doesn't use that terminology, so they're different.
Yes, I think how I would try and draw the line is I would say a vacatur is a vacatur that has the effect of shortening an extension is unlawful. But the reason it's unlawful is because it violates this provision of the statute, which says that extensions, what Ms. Bansal was talking about, extensions are effective or last until the end of the time. The government's argument for why the stripping statute covers this is based on this hyper-literal reading of this statute. They say it's any and not a. They say with respect to, not regarding or something. And I'm saying if you're going to take that seriously and ignore McNary, ignore the mountain of Ninth Circuit cases that treat determination as a term of art and just focus on the words, my question is, where in the statute does it say that the court has no authority to review a vacatur, any argument, any determination in a vacatur? And it doesn't.
All right.
I should say also, I mean, I heard them to concede that statutory claims are reviewable, which is what the two judges in the Ramos majority thought as well. So I think it sounds like we're all in agreement about that. But I'm saying this because it's relevant to our second claim as well. I think any claim involving a vacatur, even if it would otherwise not be collateral, should be reviewable because vacatures are not mentioned in the statute.
All right, so let's talk about if I were to find reviewable, first of all, that there is authority to do vacatur, and second of all, that it is reviewable. What about the merits? Is it arbitrary and capricious here?
Thank you, Your Honor.
And as I understand it, one of the reasons is that the criticism of allowing an extension or subsequent designation to sort of subsume earlier ones is somehow inappropriate, but that your view is that that's done all the time. Every time you redesignate, there is some subsumption going on.
That's correct, Your Honor. So in the 35-year history of the program, there have been approximately 36 redesignations, and each subsumed an earlier designation. That's the purpose. So for Venezuela to qualify under the 2021 designation, an applicant had to show they've been continuously here in this country since March 2021. Then when Venezuela is redesignated in October 2023, that date moves up. So you have to show continuous physical presence since October 2023. Everyone who qualified under 2021 qualifies also under 2023. So in that sense, a redesignation always subsumes the earlier designation. It's also standard following a redesignation that the filing process to re-register is the same for any applicant who has TPS under that country, regardless of when they first registered. So the example we give in our brief, and there's many, Your Honor, but Sudan was first designated for TPS in 1997. It was redesignated several times, including in 2013. Following the redesignation, there aren't two separate re-registration processes. Everybody re-registers together.
So there's nothing extraordinary about what happened here.
There's nothing extraordinary about what happened, and I believe the government just acknowledged that. They said the secretary has discretion to consolidate filing processes. And so Secretary Noem's statement that Secretary Mayorkas's consolidation was somehow novel or inconsistent with the statute demonstrates her own misunderstanding, Your Honor, because all this, it's not novel because it happens all the time. And all the statute says about registration is that you have to register, this is at C1A, to the extent and in a manner which the Secretary establishes. So I don't understand how it could possibly be inconsistent with the statute, Your Honor. Secretary Noem doesn't explain in the Federal Register notice, and defendants didn't explain in their opposition how it could be inconsistent given that all the statute says is register the way the Secretary tells you to.
What about the fact that the January 17th extension, it extended it to the 2023 designation, correct? But also had the effect of extending for the 2021?
That's what Secretary Noem said. I don't think that's correct, Your Honor. I think that Secretary Noem was conflating an individual's eligibility for TPS with a country designation. So Venezuela's 2021 designation still expires. I mean, the expiration of the current extension is September 10th, 2025, and there will have to be a new decision 60 days before that. What Secretary Mayorkas did was say, well, if you, an individual, first registered under the 2021 designation, I recognize that you also qualify under the 2023 designation because you meet that, you've been continuously here in this country for longer even than you needed to be. And so you can re-register under this 2023 extension, and you, individual, may extend your TPS status because you qualify. You are eligible under both extensions.
So if you don't register under the 2023 extension, you're still subject to the September 25 expiration.
That's correct, Your Honor.
But the effect of the 2023 extension was to allow that registration for the 2021, effectively allowing an extension for them from September 25 to October 26.
It allowed those individuals who had first registered in 2021.
We talked about earlier, once that determination is made, that the country still qualifies.
That's correct, Your Honor. And we say in our brief examples where, countries' decisions have been made as much as 159, 102 days earlier, but it's not, Secretary Mayorkas did not extend the 2021 designation. He didn't make that decision in January. What he did was extend the 2023 designation and just acknowledge that the individuals who had first applied in 2021 were also eligible. They met all the criteria to obtain TPS under the 2023 designation too, and so he permitted them to re-register.
So how is that different from actual designation?
Because, Your Honor, the individuals who had TPS under 2021, if they chose not to re-register under the extension, then their documents expire September 10th, 2025. They would still be on that other track. So they could choose to switch tracks, but the two tracks still exist.
And had the extension been granted, an express extension been granted, then there would be no need to re-register under the 2023, that everybody under the 2021 would be, that's what I'm trying to figure. What's the operational difference?
It's just whether or not there's two separate tracks with two separate timelines, Your Honor. And the two separate tracks, so if 2021 had been extended,
yes,
2021 folks would still have had to re-register, but their documents would expire on a different date. So say Secretary Mayorkas had extended the 2021 designation 18 months also. That 18 months would run from September 10th rather
or
than.
it could have extended to the exact same date as a 23 extension.
He could have tried to make them line up.
So had he done that, would there be any operational difference between doing two separate ones as opposed to doing this extension with the clarification that people could re-register even if they were 2021 designees?
Only, Your Honor, that the extension can only be 6, 12, or 18 months, and so I'm not sure mathematically if he could make them line up exactly.
Oh, you can't choose anything in between.
Correct.
It has to be.
I mean, that's my understanding. That's historically the way it's been.
So by using the extension and making it available to those in 2021, that that does result in a different timeline than had he actually used an express extension of the 2021, because that would have had to have been a 6 month, and I don't know how it lines up, but it would have been some other 6 months from September, would have been March of 26 or September of 26, but not October 26.
I think that's right, Your Honor. But again, I think the distinction is between a country designation and an individual. So if you're an individual who came from Venezuela to the United States in March 2021, you meet all the eligibility criteria for TPS, you don't have any criminal history, you are otherwise eligible. Under the statute, you qualify under either extension. And so there was nothing inconsistent with the statute about Secretary Mayorkas telling those individuals, if you want to re-register now, you can re-register now because you qualify under the 2023 redesignation. And he even says in the extension notice that in consolidating, he's not changing any of the substantive eligibility requirements for TPS. He recognizes that everybody who was eligible under 2021 is also eligible under the 2023 designation.
So this extension gives people a choice. The
Yes.
2021 people a choice to stick with their original designation, which would have ran, or to register under the 23 extension?
That's correct, Your Honor, and that's not unprecedented. That has happened at least 2 times before with respect to Haiti and Sudan, Your Honor. And so both those countries were newly designated for TPS in 2022. And when they were newly designated, at that time, individuals, there were older designations that were terminated and the determination challenged in Ramos. So for example, there were Haitian TPS holders who had first obtained TPS under a 2010 designation. That designation is terminated, but the termination never takes effect. And so DHS is publishing these automatic extensions of the 2010 designation.
Sorry, say that last part again.
In order to implement this court's injunction, DHS published Federal Register notices that automatically extended Haiti's 2010 designation. At the same time, they then do a new designation and it creates these 2 separate tracks for Haiti, sort of similar to what we have for Venezuela. And the Haitian TPS holders are permitted to get off the 2010 track and sign up on the 2022 track because they all qualify. So it's not, this is not the first this has happened as well.
And the regulation addressing this 2-track authorizes this?
No, Your Honor, there's nothing in the statute that explicitly addresses it, and there's nothing in the statute that prohibits it. With respect to the individual registration, subsection D2 of the statute, as Your Honor pointed out recently, explicitly allows the Secretary to stagger the validity periods of individuals' TPS authorization documents. So that also supports Secretary Mayorkas' ability to allow people from, who initially registered under one designation to re-register.
What does that mean, to stagger the, explain what that means.
I believe it means, Your Honor, that so that everyone's, work permit doesn't expire on exactly the same date, the Secretary could provide that work permits, some people's work permits expire on this date and some people's work permits expire on that date, as long as they are, everyone continues to have work authorization while their country designation is in effect, in order to just reduce the burden on the agency so they don't receive everyone's application at once. That's my understanding.
So the power to sort of consolidate, use an extension and allow people to go off and pat new track when they were on another track, does the power of that stem from the general power under C1 Romanet 4 prescribing the manner, et cetera, et cetera? Is that?
I think so, Your Honor. That's the only place that the statute addresses registration. There are regulations that we cite in our motion that add a little more content to that. They require registration during the period of initial designation and then re-registration pursuant to the Secretary's USCIS's instructions.
And so is your response to the concern of Secretary Noem that what Secretary Mayorkas had done was contrary to the TPS statute, a response that he had the authority, the broad authority under C1 and also, I guess, D2?
Yes, exactly, Your Honor.
what prevents the new secretary, though, from saying, well, okay, maybe Secretary Mayorkas had the statutory authority, but the process was confusing, and I also have the power under C1 and D2 to clear this up.
Well, Your Honor, I think there's a difference between fixing a mistake and changing your mind. I think what Secretary Noem said was that the consolidation was novel and potentially inconsistent with the statute. Our position is that it was neither, and so those are not reasoned explanations. Those are actually legal errors on the Secretary's part, and they don't justify vacating the extension.
Well, let's say for a moment she did get it right in suggesting Secretary Mayorkas had actually violated statute, but nonetheless, it wasn't done in a good way, and she wants to fix it. What's wrong with that?
Your Honor, I think, so we're only reaching this claim if the court were to find that there is some implicit authority in the TPS statute that allows for reconsideration.
Yeah, no, I know that.
And the courts have said that that implicit authority can extend to correcting an inadvertent clerical error. So this is the Supreme Court in the American trucking case that we cite in our brief. But it can't be used as a guise to change a decision just because you want to implement a new policy. So even where an agency has implied reconsideration authority, that authority is not limitless.
So you're saying that reconsideration is limited to fixing clerical errors?
Yes, Your Honor.
And not changing policy?
Correct, and that's American trucking, and that's also United States versus C-Train, Your Honor, which is a Supreme Court case from 1947, I believe, which is one of the first cases where they addressed this agency reconsideration authority. And they express that reconsideration merely to change your mind is disfavored, and they will not read implicit authority in a statute to authorize that type of reconsideration.
Well, one of the counter arguments is whether that reconsideration, if it is allowed at all, is so limited. It's not just merely changing minor policy, but clearing up confusion.
Your Honor, if there were confusion, which again we disagree, because this is not, instructions were quite clear. I don't know of any TPS holders who were actually confused, and the agency seems to have understood as well what the process was. That's an independent reason we've presented why the vacature violates the APA, is that if the problem was that the consolidation was confusing, the obvious solution is to deconsolidate, not to vacate the entire extension.
So, and what would happen with deconsolidation? Then each would be on their own tracks again? The 21 people would be back to the September expiration?
That would be one possibility, Your Honor, yes. And the Supreme Court in DHS versus Regents, drawing on motor vehicle manufacturers versus State Farm, says that if an agency is rescinding a prior policy, it has to consider alternatives that are within the ambit of that policy. And so, for example, in Regents, the court was evaluating the Secretary's termination of the DACA program. The reason she gave was that the work authorization and other benefits provided by DACA were potentially unlawful. And the court said, okay, but there's a whole nother part of DACA, which is protection against deportation, and it's arbitrary and capricious to rescind the whole program without considering whether you could maintain that portion. And so if Your Honor were to find that the Secretary did give a reasoned explanation that the consolidation was somehow confusing, the obvious solution would be to deconsolidate, not to vacate the entire extension.
All right, thank you. Let me hear from the government.
If I could, I do want to go back to just something counsel said regarding the jurisdictional claim and saying that this is a hyper-literal interpretation of the statute. That's the Supreme Court that has taken that interpretation. So it is what the court has told us that we are supposed to be looking at these words and how we're supposed to be interpreting these words. As to whether or not, as to the text of the vacature, the reasons for the vacature were, as Your Honor noted, it's the novel approach of combining two separate designations into one that had previously been on two separate tracks. Typically, when a secretary designates or redesignates, they do it at the same time. And so the tracks flow together. Whereas here, by having the October 2023 redesignation, that created a separate track, and we have two sets of individuals and who are covered by temporary protected status, but with different end dates. So because
there were two different tracks with different end dates.
Yes.
And the effect of this consolidation is to allow people to use the same end date, right?
Correct, and thereby over not making a determination on the 2021 designation as an extension.
I mean, so what was absent is an express determination on the 2021 country designation.
Correct. Instead allowing the...
But is that sort of obvious? The same findings that apply to the extension of the 2023, which made country considerations findings. I don't know how you could have two different ones. I mean, how could they diverge?
That's true, but the statute does say, I mean, we're here discussing what the statute says, and a decision on each designation shall be made. Once the initial designation is made, the periodic review kicks in. And so by subsuming that 2021 designation underneath the 2023 redesignation, individuals would then obtain, I think, an extra 13 months of TPS status by rolling into the 2023. So that is the novel interpretation that Secretary Noem is discussing in the vacature. But she also does state that not only is she looking at this novel approach with the extensions and designations, but she notes that she would like that the vacature provides her an opportunity for informed determinations regarding the TPS designations and clear guidance, which refers to the President's executive order. So it's not just the re-registrations and the conflating the two extensions. It's also to look at how these designations have been implemented and the underlying legal grounds for those implementations.
Well, you mean to revisit the actual designations, that not just how they're implemented, but the actual designation.
Designation, yes. Plaintiff's approach would never allow a secretary to revisit a designation, no matter what changes within the interior or the exterior of the country. And these are foreign policy. These are national. I mean, here it's a national interest determination, which is a very broad determination.
But that goes back to the question whether there's authority to revisit on those substantive determinants, those substantive designation determinations.
Yes, yes, no, everything is tied up together. To the point of whether or not the secretary can reconsider the decision, this is also something we've already discussed, in that Secretary Mayorkas took the same approach and disagreed with how evidence was weighed and vacated the terminations in order to create extensions, to extend either extend or redesignate, depending on the country.
What about the argument about if there was some confusion, that the obvious answer was to look to alternatives, it would have been deconsolidation rather than entire vacation or vacatur?
I think that goes back to the reasons behind the vacature, which again is because Secretary Noem explicitly says that she wants to relook at these determinations. And so it's not just tied to the approach of subsuming the 2021 extension into the redesignation. She also would like the opportunity to look at those determinations.
Including the 2023 extension?
Yes, yes.
So that was that. I guess that was a real driving force. It wasn't just confusion in registration. So let's put it back the way it was. Allow the 2023 extension in place and take the 2021 people out and put them back to where they were. Is really to look at the whole designation.
The whole scheme and whether or not the designation complies with the statute.
But the designation in terms of whether or not it was warranted to redesignate Venezuela as a designee country.
Yes, Your Honor.
Okay, and then the response to that is that, well, there's no power to do that, but I guess that gets back puts us back in the old first statutory question.
Yes, Your Honor.
Okay. All right. Time is flying here, so I do want to address briefly the constitutional protection claim for a moment. Again, Ramos, it's a vacated decision, not binding, but it can be looked to at least for some guidance, though it's not binding. Did find that there can be judicial review of constitutional claims asserting racial animus or ethnic animus, and that Trump versus Hawaii deference doesn't preclude factual examination for discrimination, and that the Arlington Heights test does supply the general framework for discerning whether or not there is an improper racial motive. Has anything, in your view, changed? Now, of course, the decision also said that there was insufficient evidence to show that the statements made by then President Trump actually were a motivating factor and had substantial influence over the decision makers, which was the secretary in that case. And therefore, that's why the plaintiffs had not proven an equal protection claim. But in terms of the overall question about whether it's judicial review, whether the court can consider the question, whether or not the Arlington Heights mode of analysis is still relevant, has anything changed in your view from the Ramos now vacated decision?
I'd first note that plaintiffs brought this under the APA, and this is a separate claim. So under the stay 705 postponement, this constitutional claim is not part of their APA claim, so I don't see how it can be part of their motion to postpone.
Part of their motion
to postpone under the APA.
Since it's not an APA claim.
Since it's not an APA claim. However, if you disagree getting into the claim itself, the argument now is that no, Trump v. Hawaii is the correct standard, even looking at the vacated Ramos decision. You, Your Honor, in your original motion to dismiss determination in Ramos and applying the Trump v. Hawaii standard, noted that it didn't apply in the Ramos case because the decisions there did not involve national security as a basis for terminating, and they did not involve foreign policy reasons for the basis of termination, as well as looking at you broke them out, but the third and fourth piece being the constitutional rights of the individuals. Whereas here, we're dealing with, at least in the termination sphere, we're dealing with a termination that is explicitly based off of national interest, and the secretary lays out what she views as the national interest, and that's a standard that is not discernible for the court to analyze.
Let me ask, maybe I should clarify that the equal protection claim challenges both the vacatur as well as the termination decision.
Yes.
And just look. All right. So the vacatur decision, to the extent that's being challenged under the equal protection clause, was not based on national interest. That was just based on the prior secretary acting outside the bounds or creating a problem, doing something novel. It's in the decision to terminate that invokes national security, right?
Correct.
So you could have a differential there could be a differential analysis between those two decisions.
It could. I think the vacatur, because it does reference looking at the statute, looking at and the interpretation of the statute and the executive order of the president, that it's all kind of brought together as a package for foreign policy reasons and the national security of the United States.
And
the national interest of the United States.
National interest.
Yes.
And I understand what the national interests are. That is in part based on alleged gang activity by TDA, correct? That was cited, I believe.
Yes.
We talked about that and whether there's evidence to support that. But what is the foreign policy implication then of the vacatur and the earlier termination of the designation?
If you look at the language of the FRN on page 9043, Secretary Noem notes that U.S. foreign policy interests, particularly in the Western Hemisphere, are best served and protected by curtailing policies that facilitate or encourage illegal and destabilizing migration. And so that determination of national interest, which takes into account, it's an expansive standard. It takes into account foreign policy, public safety, national security, migration factors, immigration policy, and economic considerations. So these are all pieces that are going into the national interest determination. And that
the argument is that allowing TPS status attracts legal entry, or what's the connection between continuing or not continuing TPS status for those who are already here and the national interest in not facilitating illegal entry?
Sure. I mean, Secretary Noem also notes other programs that were undertaken under the prior administration, and the CNHB program is one of them, in which individuals were able to come, and then with the redesignation of Venezuela, were then moved into the TPS status, temporary protected status.
But I'm trying to figure out, the interest is perspective. That is, we're safeguarding the national interest, national security, wherever we want to put it, and we don't want to encourage illegal entry into the United States. I understand that interest that's being asserted. Where I'm having a hard time seeing is how is discontinuing the status of present folks or extending their status, how does that affect illegal entry?
I think this is one of the issues that one goes to the Secretary's determination and shouldn't be looked at by the court.
Well, I'm just trying to understand the logic of it.
But and Secretary Noem states that I understand the perspective argument, but that it's been used in the past to promote illegal immigration because of the redesignations that then recapture, or I guess capture, individuals who had come unlawfully and trying to get back, I believe she says, to like the core meaning of TPS status.
So it is your position that the court should not test or inquire into whether in fact there's any logic or factual basis for either assertion of national interests based on, for instance, the TDA gang or foreign policy assertions that for which there's hard to see a connection, that the court can't consider that?
Yes, I think that's straightforward analysis under the 1254A B5A jurisdictional stripping provision. That goes to the termination grounds that the Secretary relied upon. That fits in, I think, everybody's definition of determination. In addition to that, a national interest is such a broad standard that it's
well, but even the Ramos, now vacated Ramos decision said that 1254 does not preclude a constitutional based challenge. notwithstanding the jurisdictional stripping, it did allow that, and the court made an inquiry, just found as a factual matter, there was no racial motivation.
Well, I think if you're looking at Trump, if you're looking at the constitutional grounds, then you look under the rubric of Trump v. Hawaii, which looks for a rational basis, and it must be plausibly related to the government's stated objective. And here, the stated objective is to protect the national interest. So we have instruction from the Supreme Court that any rule of constitutional law that would inhibit the flexibility of the political branches of government to respond to changing world conditions should be adopted only with the greatest caution. So yes, my argument is that in the context of national interest, that is a broad standard that is firmly committed to the executive branch, that it would be inappropriate for the court to go in and weigh the evidence that the secretary weighed.
All right, let me pause right there and get the response that Trump versus Hawaii has greater application here because unlike Ramos, there is at least an asserted national interest in foreign policy component, at least as it affects termination, not bigature.
And I should say the APA makes reviewable claims that agency action is contrary to constitutional right. That's in the scope of review provision of the APA. So we are raising this claim in support of the postponement motion as well. But to answer your question, Your Honor, you alluded to this earlier, national interest, that's the word the statute uses. It's not obvious that that means the same thing as national security. And in the Ty v. Ashcroft case, which we cite from the Ninth Circuit, the government had tried to claim that a non-citizen who was committing crimes presented a national security concern. And that was in an immigration detention context. And the court said, look, just the fact that it's a non-citizen committing a crime doesn't somehow transform this into a national security issue. So I think Your Honor certainly can look underneath the reasons that are given and see, are the reasons given actually national security concerns, or are they just waving the term around when what they're actually talking about is just crime? And that's certainly relevant here because the record evidence shows that, there's a shred of evidence that a TPS holder is even a member of this gang that they're talking about. And as Your Honor alluded to at the outset, under the Dudley Declaration, there's no evidence in this record or anywhere else that I can find that this gang is engaged in anything other than, or it's not even the gang, individual members of it. There are some people here in this country who are committing some crimes, and that's it. And everything else that they've said about this is just a pack of lies. I mean, the Colorado apartment complex, that's been debunked. It's Exhibit 29 of the McLean Declaration. There's no substantial organizational presence. So they can't just make pretend that it's national security and then displace all of the court's review authority for the constitutional claim, the Fifth Amendment constraint to have any force. At some standard of review, the court gets to look and see whether there's actually any there.
So your view is that in order to try to invoke the deference under Trump versus Hawaii and the invocation of the claim of national security or national interest, that the court should first understand there's a distinction between the two. National security has certain implications that are different from just national interest generally, and that the court should examine whether there is in fact a national security claim here that truly involves national security. So you almost have to look at the facts in order to determine what review of the facts, what the standard of review of the facts are. You have to look at some predicate questions.
Yes, Your Honor, and it's much in the way that would be true of a jurisdictional question or other questions. That being said, Trump v. Hawaii is very clear that the deferential standard of review there is a product of several different things. One of them undoubtedly is the invocation of national security, but also it's that the claims involve the entry of foreign nationals. And they say that a few times in the opinion, and then if you look at footnote 5, where they're specifically refuting the dissent's claim that Arlington Heights governs, they say what makes this a case triggering facial legitimate and bona fide review which they construe as a rational basis review, is the fact that it's about the entry of foreign nationals.
Yeah, no, I'm aware of that. That you would argue that's the primary point in the fact of national security or not, or foreign policy, or additional factors, but just, and they would argue, well, that's just one of 3 or 4 factors, and therefore, I understand that.
And the other one, Your Honor, is they say it's a statute giving authority to the president that exudes discretion or in every clause to the president. This is a statute giving authority to the Secretary of Homeland Security, not the president. And I think that also matters because it's not a separation of powers issue in the same kind of way. Here, Congress set a set of criteria, statutory criteria, and gave the Secretary authority to effectuate what the statute is authorizing. So there's no Article 2 overlay, nothing about presidential power operating here. Those are 2 reasons why, apart from this national interest, national security issue, why Trump v. Hawaii doesn't govern. That being said, I think we would request that the court, as in Ramos, look at whether or not we can make our discrimination claim under Trump v. Hawaii, because this case is much stronger than Ramos. Even though I thought we had a good claim in Ramos, this claim is much, much stronger on the anti-discrimination claim than Ramos. If Your Honor, if you look at, we filed it as an appendix, like Appendix A to the reply brief. We showed the timeline of the decision-making here. And what's happening here is the secretary is sworn in on January 25th. She makes the vacatur 3 days later. So whether it's under Arlington Heights or Trump v. Hawaii, that kind of compressed time for decision-making is truly extraordinary. Then the next day, she goes on national television on Fox News to announce the decision. And she, makes this slur that says, the people of this country want these dirtbags out. That is not just campaign trail statements, separate statements about Venezuela or Venezuelans. It's explaining the decision to the public. It's the reason she gives for why we have done this to the public. It includes this racial slur. Then 2 days later, they make the termination decision. And again, the next day, she goes on TV. Now it's Meet the Press. And she says the TPP program has been abused. Again, she's explaining the decision. And she repeats these lies about the prisons and mental health institutions. And she says at the end of that, so we are ending that extension of that program. Again, it's the reason she is giving to the public for why she is doing this has this lie in it. And they say, oh, we're pointing to early statements. But the reason we pointed out in our briefing that she has been making the statement for over a year, Your Honor, is to make the point that she's been lying about it for so long, she has to know it's a lie because it's been debunked again and again. We cite, I think it's Exhibit 29 to the McLean, I can't remember which one it is. There's an exhibit 26 to the McLean Declaration. We show that this lie about emptying the prisons was debunked long ago, and they keep saying it anyway. And that's a racist trope. The Young Declaration shows, Elliot Young, who's a historian of immigration, he talks about how this lie about they're poisoning the blood by sending bad people, that goes back 150 years. Same racist justifications used again and again. And here it's in the decision by the decision maker. We didn't have a statement like that in Ramos. We had one reference to America First in notes explaining a decision, by the secretary. That's it. That's all we had, and our argument was primarily based on cat's paw, as you may recall. Here, we don't even need to use the statements of President Trump and we extraneous statements either. We're just talking about why she says she has done this. And so I think it's quite a strong case under Trump v. Hawaii itself, because Trump v. Hawaii, does allow for the consideration of extrinsic evidence. It cited the president's statements, but ultimately, the court there found, whatever you think, the court found that there was persuasive evidence of legitimate grounds in national security concerns for the decision there. And that's what they said. There was persuasive evidence before that. So they found the decision could be explained by those persuasive grounds. And here, where is the evidence that heard something other than what she said on TV? What did she say on TV about why they're doing this? And there's nothing comparable to that in Trump v. Hawaii.
All right, let me turn to the government and ask, why shouldn't statements which seem to attribute group characteristics and based on generalizations and very negative generalizations about prisons, emptying the prisons, emptying mental health facilities, membership in the Trans de Aragua, it seems to defame an entire group of over 600,000 Venezuelans who are here with this image. Isn't that almost the definition of racism, when you make a generalized stereotype about an entire group and then take action on that, when there's really appears to be no basis for that generalization?
I don't think that that's what the action was taken on. I think we have to look at the text of the FRN to see all of the reasons that were taken into account for the termination.
Okay, before we get to that question, wouldn't these statements, whether or not they motivated, that's what you're arguing, the actual action, aren't they problematic in terms, aren't they indicia of a view that really engages in racial stereotyping?
I think that the plaintiffs are taking them out of context. I think when she's talking about dirtbags, she's talking about individuals who are Tren de Aragua members. And so you have to look at the statements themselves. But regardless of that, the proper standard is to go back under, as plaintiffs are also agreeing, to look at Trump v. Hawaii and see, is there a reasonable justification for this determination?
Well, and when you do that, I mean, you do have to take into account, as I think even the Ramos decision here looked at, whether there are statements that were made that might inform, what the reason was. It's true, if you apply the Trump versus Hawaii standard, it is more deferential, it is more akin to rational basis, and whether or not you can discern a legitimate basis. But I don't think that means you totally ignore, context. And here, if you look at least the factors that seem relevant under Arlington Heights, the compressed time frame, and I guess we'll see later on, what was exactly before the secretary and what was it based on. I would have to assume at this point that none of the usual documentation that you see in termination, extension, designation processes under the TPS were followed here. That is a country report, a country conditions report, the input from the State Department, et cetera. That whole process, which usually takes months, I would assume within this compressed time frame that didn't happen here. I don't know if you know the answer to that or not.
I don't know the answer to that. I have the language from the FRN that says that Secretary Noem did consult with the State Department and did look at the conditions. So I think making a fast decision is not on its own a reason to overcome the Secretary's determination.
Well, but it may inform whether or not one can, even under the Trump versus Hawaii test, whether one can reasonably discern, or whatever that language is, attribute a justifiable explanation. And I would think this might inform that question. Maybe it's like Arlington Heights with a high degree of deference, but there's still some logic to looking at all the factors, it seems to me.
You can look at, the standard allows extrinsic evidence, but again, the ultimate determination is whether or not the decision was plausibly related to the government's stated objective. Well,
all right. So the question that I'm confronted with is under the postponement statute under 705, which essentially embraces and adopts the traditional standards for interim relief under Rule 65, right? The balance of hardships, irreparable harm, public interest that I have to consider, which way does that go, and the degree of strength on the merits. And I believe that the sliding scale test applies under 705 as it does under Rule 65.
My understanding is that the equitable analysis is the same. Recall there's a case specifically to us.
All right. Well, I will take the matter under submission, at least this motion. The argument has been helpful. I appreciate council's input. But that is a framework, and obviously there are some threshold jurisdictional questions that I have to address before we go anywhere and or go any further. That I've got to address that. So I will do so. Let me ask. I know that action is going to be taken. The first consequential action occurs on April 4th. Is it?
April 3rd is when the employment authorizations expire, and I'll just point, Your Honor, there's evidence in the record, the Faro declaration, also from Jose Palma, which show TPS holders are owning businesses, lawyers are trying to figure out, what to do. People are postponing school, all kinds of things. I know it's a lot. That's kind of short time frame because of the danger. We would just respectfully request we will look at it.
Okay. And in terms of the motion for discovery, I think I've already indicated my view is that what the parties should do first and foremost is to try to agree on what the administrative record is in this case. And then I think then I can approach, if there's additional records that are then sought, then I can see in that context, but I think I need to see what the administrative record is first. So the quicker you can put that together, the quicker we can tee up any motion for discovery if there is one. I'm going to direct the parties to meet and confer immediately about that.
Your Honor, we appreciate that and certainly would seek to meet and confer with defendants about the administrative record. We would ask for an expedited production timeline for the administrative record. As a point of reference in Ramos, Your Honor required the production of the administrative record for 2 countries 10 days after the jurisdictional finding, and the other 2 countries 7 days after that. And we would request in these circumstances, given that we're talking about 1 country and 2 hastily made decisions that went into effect very quickly, that nothing greater than that timeline be allowed under these circumstances. Also, Your Honor, in the Ramos context, the guidance that Your Honor provided about what was part of the administrative record at the end of Your Honor's order on the motion to dismiss was extraordinarily helpful in providing some guidance about what should be part of the administrative record. And we request that guidance again be provided here, perhaps with even greater specificity in light of the fact that we have learned much more from the Ramos experience about some of the limitations and the limitations and the extensive motion practice that was required to try to get a more complete record. The guidance that Your Honor provided recognized binding precedent that all documents and materials that were directly or indirectly considered by decision makers and relied on by subordinates should be part of the administrative record. We've also learned in the context of the Ramos litigation about what should be part of the whole administrative record, and we would respectfully request as much guidance as possible from the
last time. I've not seen any change in law, and there may be some law with respect to extra record stuff and when the appropriate timing of that may be. If you're going to need, if you start getting into dispute and you have more specific questions, I can address those through my normal process of a joint letter addressed to me for an expedited consideration. And I agree, I have to decide the jurisdictional question first, because if I find there's no jurisdiction, there's nothing for me to do. But once I do decide the jurisdiction, I do expect the parties to produce. If you have a dispute about what goes into the administrative record, based on my criteria, send me a joint letter and I will resolve that. So that is my hint in terms of timeline and scope.
We appreciate that, Your Honor. I'd also like to make one additional point, which is that our motion to shorten time was merely a request that this court permit us to propound discovery, not a request that this court make any determination about whether the discovery that we're seeking is proper. That has been prevented because of what is effectively a unilaterally imposed stay on discovery by the refusal to allow a conference that would have opened up the discovery process. We're not seeking expedited discovery or a determination about the propriety of any discovery requests, but we do note that in addition to the administrative record that is the basis for any judicial review of an APA claim, there's two parts of our case that require, in fact, some extra record discovery. One is the constitutional claim, which requires a consideration of the motivation of the decision maker. My colleague spoke about the statements that were made, for instance, after the decisions, the vacatur decisions and the termination decisions on the media. We would like to know and have a right to know to be able to develop our equal protection claim, what the secretary relied on, what documents she considered to prepare for those media interviews in which she described TPS holders and Venezuelans more broadly as dirtbags. That would not be part of the administrative record. It is a post hoc rationalization, but it is essential.
Well, we don't know. I'm sure there may be something in the administrative record because there's only days before that might be relevant. That's why we need to see what the administrative record is first. But to the extent you are asking in advance for permission to seek extra record evidence, I think the record is evident that depending on what survives here or what, if there is jurisdiction, including jurisdiction over constitutional based claims, I think the Ramos decision and what I've held in the past and in Trump versus Hawaii, I think leaves the door open for extra record evidence, but it's part of what I'd like you to meet and confer in advance on. Now, whether you can propound discovery, let me ask, with respect to obviously you don't need to have a case management conference. It's hard to schedule one until you know what I'm doing here, but I will probably set a case management conference either way, whatever I do. Well, if I find there's no jurisdiction, still need a case management conference, and then that's going to invite a motion to dismiss, I assume, a formal motion to dismiss. But, or if I don't, and we need a case management conference, figure out where do we go from here, what's the next motion, et cetera, et cetera. So I will set a case management conference in short order. Whether you want to propound something in advance of that, I mean, you can, and I can grant that for good cause, in advance of the normal process of waiting for the case management conference to propound discovery. However, I would not require the defendants to respond to that until the jurisdictional issue is decided. But if you want to propound that as a cautionary measure just to get things rolling, I will permit that with the understanding that no response is expected yet until I rule, and then and once I rule, maybe you can stipulate to a response time if that's appropriate. So
may the government have a chance to respond?
Yep.
Just I'll do my part to keep it brief. The government's position is that there should not be any administrative record production prior to this court's adjudication of the motion to dismiss. And here, the plaintiffs just filed their first amended complaint a few days ago. So there's now an additional country added. That's going to be considered in the government's anticipated motion to dismiss. There should be adjudication of that first. I believe that's the whole reasoning in the In Re
United States Supreme Court case that threshold jurisdictional arguments need to be resolved prior to any administrative record order, and I'm not clear.
Well, that's why I said I'm not going to require a record be filed until I resolve the jurisdictional question. But once I do, even if there's a motion to dismiss, because I'm going to look at the jurisdictional question pretty much on the merits, it may not be the ultimate decision, but it's enough to get the process going. I don't agree that I have to defer any kind of action in this case until a motion to dismiss has been brought and adjudicated. It is not uncommon to have a case management conference, to have discovery ongoing. It's up to the court whether it should stay discovery pending a motion to dismiss. And sometimes I do, sometimes I don't. If you want to make that motion, you can make that motion. But my intent at this point is that since I will have looked at this question quite closely, perhaps not in the context of a 12B1 or 12B6 motion, but this is not like just out of the box. You'll see what my ruling is. And if I find that there's no jurisdiction, you don't have to worry about it. Or if I find that after looking at everything that there is, there's enough there to start the process of putting together there will be a process of putting together an administrative record. And I would not, highly unlikely, I would await a full motion to dismiss to be in that process. You can still move and convince me, but I'm just giving you a preview. Since this is unusual, since this is a very robust, among other things, merits-based preliminary injunction, I have to now look at some of these threshold issues very closely. So that's what we're going to do. So what I will schedule a case management conference either way once I get this ruling out. But I would like him being conferred to start thinking about both discovery, what that is going to look like, what the record's going to look like, the administrative record, and how we might proceed. Is this something that, motion to dismiss, then followed by motions for summary judgment, or do you skip motion to dismiss and just do it all in summary judgment? You move for summary judgment on some claims, not others. We set up a bench trial on issues where there may be some factual questions. I don't know, but I'd like you to think about that.
Brian, may I raise two additional points? Just,
Yeah.
As far as if the court determines that it should postpone the vacatur and the termination, I would note that there are 3 other cases that are looking at this exact issue, and so for you to take that into context in the scope of any decision. And then also, if there is to be a stay or a postponement, we would request a couple days for the government to determine whether or not an appeal should be sought.
Sure. All right. Anything further?
If you want to be heard on the question of whether the relief should run,
the question of
the other cases or not, I'm welcome to address it if you're honored.
Well, if you have anything to add, I've read the papers and I understand, we're all dealing partly in a bit of a state of flux here. Things are moving as we speak, probably, on this question about scope of any stay, et cetera, et cetera. I understand the arguments pro and con. I understand, and I've read the concurrence in the Ramos case, so I'm aware of the issues. I am aware of at least 2 other cases that are pending. Is it 3 or 2 other?
3 now. There's some overlap. So this one is, there's one in Eastern District of New York that's solely on Haiti. There's one in Massachusetts.
Yes, and then there's one in Maryland.
Yes.
Yeah, Maryland's only about Venezuela. Massachusetts is about both, and New York is about Haiti. The other thing I would just say, there's a footnote in the reply brief where we collect the cases as well since Ramos. It was just since, I can't remember, 2021 or something like that, where the courts have issued universal, whether it's vacatures or in some cases injunctions, and those have been upheld, including recently in the Ninth Circuit. It's an injunction on the birthright citizenship order. And then, it was in the papers, but at this point, it's well over 84,000 members. They're in every state. You cannot limit to the Ninth Circuit and give relief to the party. So already you can't do that. And so, how exactly you would enforce a postponement limited to NTPSA members The government doesn't even try to explain how that would be possible.
No, I understand the arguments. And you have an organization here as represented, and it's provided by declaration or substantiated by declaration that this is a membership organization that is nationwide with members in all states. Whether that's relevant or not, I don't know. We'll figure that out. All right. All right. Thank you, everyone.
Hearing is concluded.